Welcome to the Professional Development Series. My name is Chris Fortier. I am the chair of this series, and I'm proud today to bring you a program about how to ask a question with John Altmiller. Mr. Altmiller is a partner in the firm Tesner Kawamoto. His practice is concentrated in real estate litigation, civil litigation, business law, landlord-tenant collections, and contract law. He's tried cases in numerous jurisdictions, including Fairfax, Arlington, Alexandria, Prince William, Loudoun, Fauquier, Stafford, and Fredericksburg. Has been the lead counsel in over 30 circuit court trials. Mr. Altmiller graduated from Villanova and received his law degree from George Mason University. He is the former co-chair of the real estate section of the Fairfax County Bar Association. He is a speaker at several continuing education seminars in the area of real estate and litigation. Mr. Altmiller, the floor is yours.
Thank you. My name is John Altmiller. I am primarily a trial attorney, and so this program is going to focus largely on the types of questions that affect a litigator, primarily a civil litigator, although these are the types of inquiries that you will be engaging in as a criminal attorney as well, although I will be talking quite a bit about the civil discovery process, since a lot of the questions that are formulated and asked occur within that context. Now, in the written materials, I've started out with a bit of an introduction that sets forth an overview of the topics that we will be covering this hour. We start out with the interview of the client. Now, when you initially meet with a client who has been sued or will be suing, or perhaps is investigating what types of claims they might have, that interview that you have with the client is absolutely crucial. And in addition to learning as much as you can about the case that is positive for the client, you also need to determine potential negative aspects of these potential claims. And for that reason, the interview is very important in setting the tone going forward. It also lets the client know how you intend to go forward with the representation. That is, how focused you are going to be on details and how probing you are going to be in your questions, not just of them, but of the other parties in this case. Hopefully, this interaction will leave the client with a great deal of confidence in your ability to be an advocate on their behalf. The next is interviewing the witnesses or the potential witnesses in the case. In addition to speaking with your client, you may also be talking with third parties. Oftentimes, claims or defenses are supported by other parties, some of whom may be related to your client in some respect, either by employment or family or friendship, some who may not be. And the interviews and examinations that you conduct of those potential witnesses are, in fact, very crucial in determining how to proceed in a case and in establishing the case itself when you do proceed. Next are the questions that you will be formulating when you propound written discovery, specifically interrogatories. These are the questions that are asked of the opposing party at the outset of a litigation and are done normally prior to depositions. They have a very particular purpose, and we will be discussing those purposes and how those questions can be used in advancing your cause in the litigation. These are questions that can be used both for preparing a deposition of a party or a witness, as well as preparing for and being used at trial. Next, we have depositions. Depositions are a unique opportunity to engage in a very broad examination of parties and witnesses. This is a very broad opportunity and really special opportunity for an attorney to establish facts that the attorney is looking to establish, but also to become aware of potential facts and claims that the attorney might not have been aware of previously from either witness interviews or from discovery that was propounded. Finally, there is the witness examination at trial. This includes the examination not just of parties and of lay witnesses, but also the examination of expert witnesses. Most of the time, the foundation for these examinations will be created much earlier during depositions and in written discovery, as well as the documents that are obtained. Obviously, the testimony of witnesses and the examination that is conducted, both direct examination and cross-examination, are absolutely crucial in establishing claims and defending against claims if a case goes all the way to trial. So we're going to start now talking about the interview of your client as well as the witnesses that you might interview at the outset of a case. Now, while it is natural for an attorney to be sympathetic towards a client's cause, it's natural for an attorney to want to help that potential client or existing client. The attorney's job is to engage in an objective evaluation of the merits of the claim or of the defenses in the case of a party who has been sued. It is therefore essential that a rigorous interview be conducted. It doesn't necessarily need to be the very first interview that's conducted with the client, but ultimately, certainly prior to filing pleadings, a thorough examination of the client regarding the facts of the case and regarding the documents involved in the case, if there are pleadings regarding those pleadings. You may be confronted with a letter that has been sent by opposing counsel. You are going to want to address all of those issues. And in doing so, you want to avoid as much as you can your own conclusions, or what I call embedded assumptions. Whenever you examine a witness or you interview a client, or in general when you engage with anyone in a case, there are certain assumptions that you may bring to the table that you may not realize you are bringing to the table. And we're going to talk about some of those as we go through the material, but I do want to address that issue because a lot of what we are going to talk about involves those embedded assumptions. For example, when a client presents and says, well, my spouse is having an affair, and it's very logical for the attorney to say that's terrible and we need to base our claims and defenses on this fact, you need to look at why the client believes that. What evidence do they have? Who have they learned this information from? What do they know about it? You may find out that there is a strong suspicion that a client has concerning an affair or concerning any fact in a case, but that when you actually examine the grounds for that belief, opinion, or knowledge, that it might be something a bit more questionable. It doesn't mean that you can't rely on that fact ultimately, but you need to understand what kind of evidence there is going to be for that. This is not in the materials, but I will say this. Whenever I interview a client or whenever I'm making a determination about how to present a claim, whether to present a claim, I always think in terms of what a trial might be like. Now, what's it going to be like when I show up on the first day of trial and the attorney says, Mr. Altmiller, please call your first witness? What type of evidence am I going to have? What type of documents and testimony am I going to be able to present to the court? These are the types of questions that you should be looking at. And your effectiveness as an advocate is absolutely dependent upon your ability to discover the facts in this case as soon as you possibly can. If you don't ask your client the difficult question, it's very possible, in fact likely, that your opposing counsel is going to ask that question. And at that time, you might not be prepared for it. Learning it early helps you deal with it, helps you prepare for it. And in some cases, may lead you to the conclusion that you don't have a claim regarding a particular issue. There is an obligation on the part of attorneys, both ethically and pursuant to Virginia Code Section 8.01, 271.1, to only proceed with meritorious claims. And the failure to do so subjects a client to ethical sanctions as well as monetary sanctions from the court. So, although you may initially believe after an interview that a client has a particular claim, you need to consider at all times, is there new information? Have I found out additional facts or evidence as a result of my inquiries of the client or other witnesses? Another thing is listening critically to the answers that the client is giving to you. Is the client being direct, or are they being evasive? Do they seem to be glossing over certain facts? Do they seem to be trying to minimize negative facts in their case? Are they trying to, in short, as some people like to say, manage the facts? Are they trying to tell you how you ought to think about the facts? That indicates a couple of things. First of all, it might indicate that there are problems, factual problems, that you're going to have to confront. It also might indicate that they're going to be bad witnesses, that when they are put on the stand and they are asked similar questions, they will be similarly evasive and provide similarly difficult answers. So it is always beneficial, within reason, to be, as I said, as rigorous as you can with the client in the questions, and also critically listen to those answers. As you get more experienced, you will learn the types of answers that might be used to obscure the truth in a case. And you have to consider often that clients want you to be on their side. They want you to like them. They want you to work hard for them. And sometimes they will shade the truth as a result of that, or they won't tell you everything, or they might tell you things in a particular way. You need to be aware that this can happen and, in fact, does happen. And for that reason, you need to ask questions that will challenge your client. Ultimately, you are going to have to be comfortable enough with your client to ask them those types of questions and to not protect them, so to speak, but rather to expose them to the type of inquiry that they may receive from an opposing counsel. And I don't know any attorney that has not had the experience of learning something about their case, oftentimes from the lips of their own client at a very inopportune time, either at deposition or worse, even at trial. And you can't always protect against this happening, but a very thoughtful and careful examination and critical examination of your client will help avoid these types of circumstances. So another thing that you will experience when you talk to your client is you will learn about third parties who may have testimony regarding this case. And you will then, in turn, oftentimes informally, be asking those potential witnesses questions. Now, oftentimes those witnesses will be presented as witnesses who are favorable to your client. The client will say, Bob, he'll completely support that the following things happened, or he was a passenger in the car, or he was my roommate, or he was an employee at the time, or what have you. And they will say, he's going to support my version of events. You need to be careful when you ask those witnesses questions, because when you talk to witnesses, they oftentimes, and this is a theme in my materials, the witnesses will oftentimes not want to be confrontational. They'll want to help. They will not want to be contradictory if they can avoid it. And so you will get very agreeable answers at that time, answers that might not be the answers that you receive when that same party is deposed or called to testify at trial. So an example that I give is if you've got a witness to an auto accident, it's a much better question to ask how fast was the other vehicle traveling at the time of the accident, rather than to say, my client has told me the other vehicle is traveling at 35 miles an hour at the time of the accident. Is that true? Rather than create a circumstance in which you're looking for confirmation, you're looking to preface your questions with the things that you already believe you know. It is much better to ask the witness initially what they know about the case. And you should be formulating questions based on that. Again, it's very easy to go into an interview of a witness believing you know a lot of things. And this is, by the way, a problem that can come up in trial examination. It can come up in depositions and in other circumstances when you are asking a witness or a potential witness questions, and you believe you know what has happened, either because your client has told you or for some other reason, or because of assumptions that you've made, and the witness gives you unexpected answers. In an interview, you should use that opportunity to explore what that witness believes that they know, rather than challenging them necessarily, rather than trying to shape their testimony. Because if you try and control their testimony and get them to say things that are different from what you know, you may ultimately have a problem when that witness is examined in depositions or otherwise. So it's a very careful undertaking. You should also not assume that the witness has the same worldview or opinion of events. An example that I've given is that the witness may describe the events very similarly, at least factually, but may think differently of those. In the example I've provided, you might want to ask them whether or not they believe your client acted reasonably under the circumstances. Or, for example, in an automobile case, the car was traveling at 35 miles an hour. Do you believe that was a safe speed under the existing conditions? You may find that they substantially agree with a factual statement, but they disagree quite a bit about what the implications are of those facts. Certainly, lay witnesses, certainly in Virginia, are permitted to give opinion testimony on a wide range of topics, and you should always be aware that the lay witness may be providing those opinions at some point in time, and that those opinions may in fact not be commensurate with what your client has described to you or even what you think about the case. In interviewing an expert witness, which is something that the previous rules certainly are applicable to, about the embedded assumptions, about asking questions to really get a notion about what their thoughts are, you need to think about what the foundation of all expert testimony is, which is, first of all, their education and experience, which is the basis of their expertise, and also the information that is being relied upon in providing the opinion, which is also known as the grounds of the expert opinion. Particularly in the case of the grounds of the opinion, you need to determine what information they have that might form the basis of their opinion, or more importantly, what information they will need in order to provide the opinion that you are looking to obtain. So that if you say to contractor, I need to know whether or not this work was done in a workmanlike manner so as to pass without objection in the trade, or I need you to offer an opinion about whether or not these things are code compliant. You need to find out what information they need, what type of inspection they may need to conduct, what kind of other additional information they may need to get from your client. The sooner you find that out, the sooner you can get that information, and the sooner you can get an opinion and find out if that opinion is going to be supportive of the claim that you are looking to make. You also want to determine what kind of experience they have had. Have they testified before? Have they testified for plaintiff or defendant? Have they ever been rejected as an expert? Have they had publications? You want to establish some notion of what you can present to the court in voir dire, which we'll talk about a little bit later, when you offer this witness up as an expert in a particular topic. Another thing you want to do is make sure you have some agreement with regard to terms. Attorneys like to use terms of art because our profession requires it, as do other professions. So you have an expert that is going to use various terms. I had a very rude awakening when I dealt with handwriting experts who have these various terms that sound variously weak or strong, perhaps weaker or stronger than the standard they are really conveying. You need to explore the meaning of the terms that witnesses are using, because they may use words that sound like they mean one thing, but in fact have a different meaning within the profession or expertise of that witness. So a related issue is the establishment of the legal standard. Ultimately, you may need an expert witness to testify about the standard of care, about, for example, in construction cases, whether or not something is performed in a workmanlike manner so as to pass without objection in the trade, whether or not something is within a reasonable degree of scientific or medical certainty. These are standards that are absolutely crucial. It's not enough to say that somebody did a bad job at something, or that somebody was not mindful, or you wouldn't have done that, or whatever an expert might say. You need to make sure that you are getting confident, clear testimony with regard to the legal standard. Again, the sooner you find these things out, the better. Another aspect of asking questions in the context of a litigation is evaluating the claim that you have. And part of that is asking questions about the legal duties, and part of it, as I've alluded to before, is about exploring some of the assumptions that you might have had. When I was in school, a lot of this was called issue spotting. Somebody comes to you with a set of facts, and the object is to find out what type of claims they might have, or if a claim has been made, to identify what kind of defenses might exist. Are there elements that are missing? Are there affirmative defenses that are present? That type of thing. So as an initial matter, you always want to examine in various claims whether or not there's a contract between the parties. It's something that seems fairly obvious, certainly in a contract case, but it's also something that comes into play in other cases. You may have a claim by an employee against an employer. Well, is there a contractual relationship? Does that give rise to additional claims? Does it potentially defeat other claims? In Virginia, the existence of a contract can, in some cases, arguably in many cases, effectively eliminate claims for tort. So if you have a real estate transaction in which you want to claim that the seller committed a fraud, you need to look at whether or not there's a contractual arrangement. For example, I have a client now who's being sued for fraud. Although you wouldn't know it from reading the initial pleading, there was a contract between the parties, and that contract does a lot to potentially defeat that fraud claim because it makes clear that certain representations are not being relied on by the parties. So you want to look at whether there's a contract. You want to ask yourself, is there a contract? Is it between the parties, or is it between some other parties? Are some of the parties third-party beneficiaries? When and how was the contract formed? Were there counteroffers? Were there rejections? Is the contract in writing? Is it in some other form? Is it implied in fact? Is it implied at law? If there's been a contract claimed in a case, has it been attached to the pleading, or has it been referenced in the correspondence between the parties? You also want to look at who the parties are, particularly when you deal with contracts. I can't tell you, there have been quite a few times that I have made assumptions about who the parties were to a particular contract because of the way a particular transaction was presented, only to discover that parties were different. A client says, I signed a contract to sell my house, now the purchaser won't go to closing. Well, it turns out when you look more closely at the contract, the seller is actually a living trust. Well, you need to look at those things, and then you need to ask, sometimes, if it's a contract to sell real estate, does that person actually own the real estate? If there are contracts, it's helpful to look at whether or not people had authority to execute a contract, if it was signed by a corporation rather than an individual. This is important, particularly when you deal with people who have licenses, who are supposed to have licenses. Contractor may be licensed, but if he signs a contract in the name of another entity, a related entity that's not licensed, that's going to create problems for that contractor, and certainly may very well create defenses to somebody who's being pursued by such a contractor. Additionally, you want to look at what the terms of the contract are and not make assumptions. Ask, are there affirmative duties? If you are making a claim or a claim is being made against your client, what duties are in the contract? How are they spelled out? Are they ambiguous? Are they clear? Are damages limited? Are actions limited by other conditions precedent? For example, notice. For example, performance of some act. Are there contingencies that come into play? If so, how are they invoked? How are they limited? You need to look at those types of things. Beyond contracts, you want to look at other legal duties. Are there statutory duties or statutory claims that are out there? I've listed any of a number of the many types of statutory claims that a practitioner will see in Virginia. Unlawful detainer, will contest, partition, declaratory judgment, applied warranties on new homes, divorce and custody cases, mechanics liens, Consumer Protection Act. These are all claims that are addressed by statute. In some cases, the statute will set forth the specific elements. In some cases, they will set forth some of the requirements, some of the limitations, that type of thing. You want to be aware of that. Even something as simple and old-fashioned as, for example, an ejectment claim, there is a statute on that, and that statute talks about the things that need to be alleged. It's always helpful whenever you're making a claim in Virginia to ask, is there a statute that addresses this? And if so, does it broaden or limit my claim in any way? Does it create any requirements? Does it set forth any defenses? You want to be looking at those. Additionally, you want to look at tort duties. Things like negligence or intentional torts like defamation, trespass. There are all kinds of legal duties that are out there. You want to look at those duties. In Virginia, the courts are much less concerned with what you call something, what its name is. They're much more concerned with what duty are you alleging, what is the essence of the claim that you are making. So you want to look at those duties, and you want to ask, parties have duties to each other. And furthermore, you want to ask, in connection with all of those, what are the relations of the parties? For example, is there a principal-agent relationship? Is there attorney-client relationship? Is there an employee-employer relationship or some other fiduciary relationship that might exist? For example, if you have a principal-agent relationship, that might defeat a tortious interference of contract claim because an agent can't interfere with the contract of their own principal. Or if there's an attorney-client or even a real estate agent-seller relationship, that can create a fiduciary duty. These types of relationships can dictate the duties that exist or, in some cases, the absence of duties. A lot of what I've talked about, and I want to address more directly, are these embedded assumptions that you have, that we all have, with regard to cases. There are certain types of cases that, after a while, you will encounter a lot of, and you will begin to use that shorthand analysis that we all end up doing as a time saver because we know these cases. We've dealt with them before, and these are the bases of a lot of assumptions that go into these analyses of cases. And the assumptions themselves are not necessarily bad. We need to engage in them, but we also need to sometimes step away and ask questions. What am I assuming here? What parts of this case have I taken for granted and not really examined? A lot of times when you write a detailed letter to opposing counsel, you should be asking those questions. If you are making a claim or offering a defense to a claim in a correspondence, you should be reciting the facts. You should be reciting, in some cases, the legal principles that are applicable. Sometimes it's that process that helps you identify those assumptions. It's by asking those questions. I recently had a circumstance where I was writing a letter to a party in a contract that I am extremely familiar with and had certain assumptions about the attorney's fees clause. It had recently been changed by a colleague, and we all believed we knew, including the author of that provision, what it meant. And when I was writing the letter, I went directly to the provision because I said, now, does this provision say what I think it says? And when I looked at it to quote it, I realized that it didn't. And in fact, I had been assuming that it meant something that it didn't. And when I called other practitioners, including the person who had drafted that provision, I discovered that the author of that provision, in fact, had the same misapprehension about its content that I did. So, again, the assumptions are not always obvious, but the more questions you ask and the more critically you examine your case, the better off you're going to be. Similarly, we all have our own, for lack of a better word, worldview. There are things that we think are reasonable or unreasonable, things that we think are wise or unwise. And you have to allow for the fact that people are going to be motivated by different things. And so when you ask a question of a client or even a witness, they may give an answer that seems inconsistent with your understanding of the world. And as a result, you may think that they are manufacturing the answer or the motivation. They are constructing a different narrative to try and explain things that you think is not reasonable or not true. In those cases, you need to go back and say, now, is it possible that there is simply a different way of looking at this? For example, you may presume that your clients would be motivated as you would be in a certain case only by the financial bottom line. In fact, they may be motivated by numerous other difficult-to-explain motivations that have to do with their particular psychology or their particular values. In a divorce case, you may assume that you understand the motivations of a parent because you are a parent, but in fact, they may be different. And in asking those questions and receiving those answers, you will sometimes see, and you'll see this at trial and you will see this at depositions, you will see an attorney be dubious of the motivations or the genuineness of the response and openly question that. And that might happen in a circumstance in which the audience perfectly well understands the motivations of that witness or certainly believes that they do. So should always be aware to the extent that it's possible that you might not understand what's motivating a particular witness. And it does not necessarily mean that their answers are per se not credible. Now I want to move into discovery, which is the basis of a lot of formal questions. And what I want to talk about is, first of all, talking about how to frame questions and particularly written interrogatories. So what I'm going to talk about now is going to apply a lot to written interrogatories. To a lesser degree, it applies to requests for admission or to document requests. We're going to get into depositions after this section. First of all, whenever you ask an interrogatory, you want to define your terms. Now, there are some, in fact, many attorneys who will use defined terms or definitions at the beginning of their interrogatories or document requests. And while that certainly seems to offer some clarification, one of the problems with that is that if you want to use an interrogatory at trial, it's a lot easier if the interrogatory itself is a self-contained question. So one of the things that you want to do is you want to be very precise in the way that you use terms and in the way that you define the terms that you use. So if you want to be specific, for example, in a contract, one of the examples I've used is rather than say something like state the date and location upon which you assert the defendant executed the contract in question, you can be much more specific and say state the date and location upon which you assert the defendant executed the contract for sale dated December 1st, 2011, as alleged in paragraph 23 of the amended complaint. References to dates, references to specific documents, specifically references, as we will get into, to specific allegations or defenses asserted in the pleadings is a great way not only to offer specificity and to avoid evasive answers, it is also a way of avoiding objections because it puts you squarely within Rule 4:1 of the Rules of Court. Another way to be effective in asking questions in interrogatories is limiting the scope. There's sometimes a tendency to engage in broad questions, state every communication you've had with regard to anything related in the complaint that has been alleged. You're really inviting not just an objection, but a very broad answer. If you are looking for certain types of communications, certainly if they're temporally limited or limited by subject, feel free to do that. On one end, you want to use discovery to find the broadest amount of information, but you don't want to outthink yourself. And furthermore, again, you want to avoid objections, which is why you want to be very familiar with Rule 4:1, specifically 4:1b1, which addresses what is within the scope of discovery. It regards any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to a claim or defense of the party seeking discovery or the claim or defense of another party. And that's important. The notion is that it's got to be relevant to a claim or defense. And whenever you ask a question that is clearly tied into something that has been alleged in the complaint or something that has been asserted as a defense or even a denial in the answer and grounds of defense, at that point you have essentially immunized yourself from any reasonable objection. And it's very hard for somebody to object to a question that says, state all the facts upon which you rely to support the following allegation that you've made in paragraph 15 of the complaint. It's very hard to formulate a reasonable objection. The other party might object to it, but it's not going to be very well received by the court, and most often those objections are withdrawn before anybody gets to a motion to compel. This also brings us to the issue of how to use questions to effectively corner your opposing party. And the essence of this really is positing questions that do get at the heart of what they've alleged and the defenses that they've put forth. Certainly you might have a couple of broad questions that are designed to gather in all of the information that might be related to communications or documents and so forth. And to a certain extent, you can't avoid the breadth of those questions. On the other hand, there ought to be quite a few of the questions that you are posing that are specifically designed to get at specifically what information the plaintiff or defendant has with regard to a particular claim or defense. The example I've provided is when you have a claim of conspiracy. If you have a claim of conspiracy, you want to ask them specifically with regard to those allegations, what specific conversations are they talking about, or do they have information regarding specific meetings, dates and places, the nature of the agreement between the parties, those types of things. People will be very free to allege a conspiracy, a fraud, and so forth. An interrogatory ought to be very specific about saying, now, what is it that you are talking about? And not just in general, what are you talking about in these specific allegations that you make? Relating your questions to the pleadings is very effective in that regard. Furthermore, you want to ask questions that are designed so that a lack of response will be valuable to you. If you ask a question stating, what facts do you rely upon, or what documents do you possess to support a claim of conversion, a claim of defamation, a claim of breach of contract, or state what the terms of the contract that you allege were if you're alleging an oral contract. The failure to respond to a well-framed question will allow you to say at trial they cannot present any evidence on this issue because they have failed to provide any information. I have asked it, and if they say none, then so be it. Now, sometimes you will deal with a party who realizes that they are cornered, realizes they don't have information to support the claim, and will object to it for one reason or another, or try to avoid answering it. Again, by framing the question within the context of the allegations made by that party, and sometimes using the specific language that they employ, will get you past any reasonable claim or objection in that regard. Now we're going to move on to deposition. Depositions are, as I said at the beginning, a very unique opportunity to ask a broad array of questions, far broader than you could reasonably ask in interrogatories and far beyond the scope of what is permissible at trial. One of the things it allows you to do with a given witness is to really explore their background so that you have some understanding about where they're coming from. What is their work experience? What is their education? Where have they lived? If they're offering answers to questions that seem to indicate opinions about the reasonableness of something or the truthfulness of something and so forth, it helps to be able to drill down a little bit deeper and find out more about that party. You're creating a context to these answers. If somebody is saying in one part of the deposition, in my experience, this was a strange way for a contractor to act, it's helpful if you've got some sort of colloquy earlier in the deposition that indicates that they have a great deal of experience with contractors, or perhaps that they don't and that the opinion is not of much value anyway. So you want to be aware both on the pro and con side, both for the benefit of your case and potentially for the detriment, that these type of background questions are going to be out there. I can certainly tell you in my experience, I have occasionally learned very interesting things about my clients and about their background just by attending their deposition, because the opposing counsel went far deeper into my client's background than I thought was important. And maybe it wasn't important, but it's interesting to note that those are the types of circumstances that will arise during a deposition. In connection with that, you really shouldn't be afraid to go off your script if you get answers that you don't expect. As I mentioned before, some attorneys are flummoxed a bit when they get answers from a deponent that they think is at odds with their view of the case, and therefore they question whether or not it's true, or they question whether or not it really reflects the evidence in the case or the motivation of a reasonable party. And so the thoughtful attorney simply follows that thread and says, I've prepared questions, and it should go without saying, but you should be very well prepared for a deposition for the types of questions you're going to be asking. And if you get answers that are unexpected, that somewhat confound or challenge your assumptions, you should be willing to go beyond that. You need to have an open mind. You need to listen to the answers that you are receiving and allow the deponent, in some cases, to develop that information. You need to know, because if you simply say, I don't like that answer, I'm going to move on, or I'm going to simply be argumentative with regard to it, then you may miss out on some very relevant evidence that's going to be introduced at trial. That is not the same thing as saying you should allow witnesses to walk all over you and just accept anything they say without being challenged. But you need to balance those two objects when you are engaging in examination of a deponent who has gone a bit off script. Sometimes you will see a deponent go way off, and sometimes they will contradict things they have said in other statements, contradict things that they have said in interrogatory answers. I have always been satisfied when a party testifies at odds with their written discovery. I don't feel the need to engage them in a challenge. It's enough to ask the question and to thoroughly establish the contradiction, because it's going to really cause them a great deal of trouble at trial. I had one particular party, for example, who was a corporate designee, and in the middle of the deposition said, I'm not the manager of this company, and I haven't been for 2 years, and I really don't know anything that you're talking about. Well, that was pretty much the end of that guy for a witness, and it was really effectively the end of the case. I didn't need to challenge the guy. I got the answers that I needed. Similarly, always follow up. If you get these additional or new facts or new issues that are raised by a deponent, particularly if they're a party, follow up. There may be something valuable there. There may be something more that you hadn't expected. You may find a new defense or a new claim. There was a recent case in which a party lost a several $million-dollar commission on the basis of lack of licensure, and the defendants at first didn't know that the plaintiffs weren't licensed, and they found out in discovery. And I've certainly seen that happen in a number of cases. I saw one case where somebody was claiming a brain injury, and at the end, almost as an afterthought, the attorney asked at the end of the deposition, have you ever used illicit drugs? And deposition blew up, and people were taking the fifth, and it was not a good situation for that plaintiff. And the question was asked, it was followed up, and to great effect for that particular defendant. Now, I want to say something about using documents, because it's a fairly standard procedure in depositions, and I think it's worth mentioning that generally the practice is to ask the deponent question and without any documents, and then to come back with those documents. There's a number of advantages to that, which I do address in the materials. One of them is that you'll have deponents who will be threatened by the fact that they know you have documents and will give very tentative answers and demonstrate that they're not really very confident about their testimony. In some cases, they will confidently testify about things that are clearly not true because you've got documents to refute them. And when they are confronted with those documents, it puts them in a difficult spot, often leading to them making admissions that they wouldn't have made earlier by catching them off guard. Another aspect of this is that you always want to think about using and receiving answers that are useful at trial. And specifically, one aspect of that is in establishing the foundation of documents. If I've got documents that I want to introduce, but I can only effectively get them in from the defendant or from some other party, I need to establish in my deposition that that foundation is created, or else I'm going to have to find another way to get those in. I need to know that. So I'm always coming in with a list of documents that I need admitted and checking them off to make sure I'm asking questions to establish them. Always be aware that there's a transcript. And think about the fact that that transcript is going to be read as a transcript. Things might be happening in that room that make sense to you or even the parties in it, but they don't read very well. You may think you got a very good admission out of somebody, but it doesn't quite read that way when you are looking at the transcript. So if you think you've gotten an admission from somebody, sometimes what you need to do is simply reformulate it in a direct way. So throughout a colloquy in which you think you've gotten an admission from that party, it's very conversational. Sometimes it happens that way. Stop for a minute. Again, I've given an example here when somebody might, in the course of a back and forth with counsel, concede that they probably didn't give notice to somebody in a case. Just ask it outright. Stop for a moment at the end of that and say, are you saying that you never provided notice to the plaintiff that you were terminating the sales contract between the parties? Answer, yes. You want to get that. Also, when you ask that question, you might find out that they're really not willing to admit that it seemed like they were admitting it, but they really weren't. You don't want to find that out at trial and then have a muddy transcript to back yourself up. It's not going to get you very far. So that's very crucial. You want to try as much as you can to avoid using verbal crutches. Sort of, I mean. It's hard to avoid doing that. That's the truth. You will have various crutches. You'll have some ahs and ums, although most of the court reporters will avoid putting those in there to a certain degree. One of the things that you will find, particularly if you're new to doing depositions, and in many cases after you've been doing them for many years, is at the end of an answer, you will say, okay, and then you'll ask the next question. So you'll read your questions, and every question will start out with okay, because you've just said that at the end of what the answer was to your prior question. So to the extent that you can avoid that, try and be aware of it. Always read your transcripts. Most people I know are at least somewhat mortified when they read some of their questions and answers, but it's a very important exercise to engage in. Also, strike questions when they've lost clarity. Sometimes you will begin asking a question, and halfway through it, you're going to realize, I don't really know where I'm going with this, or I don't really think that this question is going to end up being very coherent. Just strike the question, move on to the next one. If you think you've gone too far, or you find yourself asking a compound question. It is hard to formulate these questions. It is hard work to put together a focused question that is designed to get the answer that you need. And particularly if you've gone off script, and particularly if you've gone into areas that you didn't expect, you're not going to always be prepared to ask the perfectly worded question. This is something that you develop after practice. But all of us are going to ask questions that halfway through we wish we hadn't asked. So, again, don't be afraid of doing that. I want to talk a little bit about trial examination. Now, hopefully by the time you've gotten to trial, you've deposed the major witnesses and you're ready for the kind of testimony that you're going to get. It's not always the case, but hopefully it's the case. If you are putting on your witnesses and presenting your exhibits at trial, put together the theory of your case and so forth, you need to ask yourself, who's my audience? And do I have a bench trial? Do I have a jury trial? Who am I trying to impress and how am I trying to impress them? What is my legal standard, and how likely are they to understand that legal standard? It's a very humbling experience to try cases in front of juries, particularly if you're not experienced in doing so and you're used to trying things in front of judges, because you realize that the questions that we all assume we know the answers to, and that everyone knows the answers to, a jury doesn't. They have these questions. They haven't seen everything. In a bench trial, it's a lot simpler. But even in a bench trial, there are facts that you know because you've been dealing with this case, and you don't consider the fact that the judge or the jury might not be aware of those facts or even view them exactly the same way. One of the things about an examination, particularly if you're doing a direct, is that a lot of short questions, even though they are more questions, even though the number of questions are greater, will actually flow a lot more smoothly and will go a lot more quickly. So, in the example that I've given, rather than make some presumptions about ownership of property or contracts or things like that, you can break it down into the pieces. Are you familiar with the property located at 123 Maple Avenue? Yes. Are you the owner of that property? I am the owner. Did there come a time when you sought to sell the property? Yes. When was that? August of last year. What actions, if any, did you take to sell the property? I hired the defendant as my real estate broker. Did you sign any agreement with the defendant? I did. I signed a listing agreement. I would direct your attention to what has been marked as Plaintiff's Exhibit 2. Can you identify the document? That is the listing agreement I signed with the defendant. Here you've broken up the facts, one question for one fact, and rather than present a document and then have to backtrack in explaining it, you've established his ownership of the property, his desire to sell, the time frame, the fact that he was dealing with the defendant, and now when you present that document, all of the relevant facts and foundation have been created, and you don't have to worry about objections regarding foundation, and more importantly, you don't have to worry about confusion on the part of the trier of fact. Similarly, don't assume that the judge or the jury understand technical terms, even terms that you don't think are that technical. I do a lot of real estate. When you talk about refinance or short sales or quitclaim deeds, these are terms that we use all the time, but that might not be well understood if you're doing a construction case. Similarly, certainly if you're doing a medical malpractice case, you want to make sure that all those terms are well defined and set forth. You also want to do what I call show, don't tell. If you don't want your client, particularly if they're testifying in a direct examination, to tell people what they should think about a fact, don't say the defendant was threatening towards me. If you start out that way, people are going to say, well, why are you saying that? And why should I believe you? And what does that even mean? On the other hand, if you explain the facts, as I've set forth a colloquy here where the plaintiff describes the contact that they've had with the defendant, and after saying things that anyone would agree were threatening, you can ask, did you feel threatened? And then the plaintiff says, I did feel threatened. Well, that makes sense because you've asked the questions that have set up the foundation where by the time you ask that question, everybody in the courtroom knows the answer because everyone else would think to themselves, yes, I would feel threatened in that circumstance as well. You're not telling them what to think. You're presenting the evidence, and then you're tying it together. If they didn't get it before, oh, yeah, that's right, that was threatening now that I think about it. So one of the things that you want to do is, in avoiding objections, as I've said, is you do want to create that foundation. You want to establish, for example, in the case of photographs, if you've got a photograph of something, you don't need to ask the person whether or not they took the picture. In fact, it's really irrelevant. You want to ask them, is this your property? Have you had an opportunity to see this property? Or if it's not their property, have you seen this property before? Yes, it's my mother-in-law's house. Were you there during April of 2012? Yes, I was. I'm going to show you some pictures. Is this what the backyard looked like at that time? Yes, it was. Now you've established the foundation. The answers to those questions are going to get those pictures admitted. It doesn't matter who took the pictures. So you always want to be thinking about what the foundation is. The foundation is, how does the witness know the things that the witness is saying? How is the witness identifying the documents that the witness is identifying? You also want to establish that foundation when you have an expert, true voir dire. As I've stated in my materials, the voir dire is important. Not always. In Virginia, there's a notion that the bar that has to be reached for an expert is not that high. They simply have to know more than the fact finder. There are some judges who are a little bit more stringent, and I've certainly had some circumstances where I've had to work a little bit harder on a voir dire than I would have expected. But you do want to establish their training, you want to establish their licensure, you want to establish their experience in certain areas. Similarly, if the other side is voir diring a witness they want to use, you can go down that road. What you don't want to do, certainly if you're on the other side, is challenge a witness who's clearly qualified so that we're spending a lot of time talking about their experience and qualification. If you've got a very qualified expert, oftentimes the other side is going to say, that's fine, we accept that they are a witness, or they are qualified as an expert rather, because they don't want to go through how well qualified that witness is. Similarly, even if it's going to be an easy time voir diring them, you might go a little bit farther than you normally would. You don't want to test the court's patience on that, but it is going to be helpful. A few issues at the end here involving hearsay and leading questions. Hearsay is interesting not simply as an objection, but because oftentimes people are going to testify about what somebody else said, and it's going to be hearsay, and oftentimes it's not going to be hearsay. The example that I give is you ask a party, why did you leave the building? Because Peter told me the building was on fire. That's acceptable. That's not offered for the truth. Now, if you ask that same person, why did you leave the building? And they say, I left the building because the building was on fire. And you say, how did you know the building was on fire? And they say, because Peter told me. That is hearsay because you are asking a question That is, the answer to which is indicating that they believe the property was on fire and it was because somebody told them. Now you're introducing it for the truth rather than to support your actions. You should be aware of that distinction, and you should be framing questions in direct examination to avoid that problem, certainly in cases in which you're trying to get what might otherwise be hearsay admitted. There are exceptions as well, and certainly I would commend everyone to look at those exceptions. Finally, I'm going to mention leading questions. There are certain times when you can use leading questions. First of all, obviously in cross-examination. In fact, there are some commentators that will tell you cross-examination should consist only of leading questions. I don't know if I entirely agree with that, but certainly primarily leading questions. You're allowed to do it if you call somebody in your case in chief who is a hostile witness or an adverse witness. So if you call the defendant in your case in chief as the plaintiff, you're going to be allowed to use leading questions, although you want to be careful because you might be bound by certain answers that come out, and it's always tricky calling hostile witnesses to testify in your case in chief. Now, there are times also under Rule 2:611C, the court has discretion to allow it to, quote, allow a party to develop testimony. It means if you want to go through some things that the parties really don't dispute but you need to get in, you can run through that stuff fairly quickly. Although oftentimes you can establish that if you're smart ahead of time by creating stipulations. But you should be aware of when you are allowed to use leading questions and not. And leading questions, for those of you who are looking for a definition, would be a question for which the answer is implied by the question itself. And they're very effective for getting people to admit things, for saving time, for getting people to give you the testimony oftentimes that you need. If you want to know the difference between leading and direct, I think the first time you have to do a direct examination that you're not entirely prepared for, and you will lapse into leading question, and sometimes you will get objections. And it is not always easy, particularly if you don't have a prepared witness or a witness that is going to answer in the way you would like them to. So that is my presentation on how to ask a question. I appreciate everybody's time and attention, and I will leave it off to the moderator.
Thank you very much, John, for your time and detail to this topic. Please follow our professional development series on our website or on our social media at the addresses provided on this slide. Thank you very much for listening, and have a wonderful day.